So today we've got an hour's session, and you will hear first from myself. I'm the campaign manager for Ban the Box here at Business in the Community. I both lead the campaign and also work directly with companies to support them to increase access to employment for people with criminal convictions. You will also spot that we've got a slightly different name from Adnan's today. Unfortunately, Sadie, who was going to join us today, has had to pull out very last minute. And Kelly has kindly stepped in to take over on her behalf. So Kelly White is the Senior HR Advisor at Adnams. And finally, you will hear from Tony Hay, who is the Future Talent Manager at RICO. Now, I mentioned the Q&A, the comments panel on the side of the screen. That's also where you can submit questions to us. As we go through the webinar today, you will have the opportunity to pose some questions, both to Tony and myself, and possibly to Kelly, although as she's a bit of a stand-in today, we won't be posing any difficult questions to her. Please do submit your questions as you go through, and when we get through the full presentation, then we'll have some time at the end for those questions to be asked. I know that many of you have also submitted questions during the registration process, and we will have a chance to get to those too. So firstly, I will explain a bit about Ban the Box, the why, the how, and some of the legislation that impacts on employers. And then secondly, with our focus on diversity today and the impact of Ban the Box and the potential that it has to increase diversity within workforces, I will give you a bit of an overview of the connections between the two issues. But firstly, what is Ban the Box? The campaign launched back in October 2013 and aims to create fair opportunities for people with convictions to compete for jobs based on their skills and experience. It provides a really simple step that all employers can take to increase that access to employment for people. We're asking UK employers to remove that default tick box that often appears on application forms and asks about unspent criminal convictions in order to consider applicants' skills, experience and abilities for the role in a more considered way before asking about criminal convictions. We're also hoping that employers will publicly commit to doing so in order to increase the visibility and accessibility to their roles. And really, I guess the question that's often asked to us is, why are we focusing on a tick box at all? And the reasons for us are really clear. It is often used to exclude, and whether that's inadvertently because you've seen that information and it's very difficult to forget that once it's appeared on an application form, or through choice of the employer. We do know that 75% of employers have in a survey admitted to using a criminal record to exclude a candidate, whether that's outright or to pick someone else over and above that applicant with a criminal record. And unfortunately, 1 in 7 would reject an applicant with a criminal record regardless of the nature or relevance of that conviction. What we are trying to achieve through this campaign is highlighting that that tick box just doesn't provide any information on the conviction and its relevance to the role. It really doesn't serve any purpose or help anyone in that recruitment process. Not only that, it also puts people off applying. So we would suggest that by removing a tick box and finding a new way to ask about criminal convictions, you will have access to a new and different talent pool. Now, I mentioned just now that it can put people off applying, and that's something that we hear more and more as this campaign has grown. And of course, not everyone that applies will be right for your role, but there could be the person out there who is the best person for the job and happens to have a criminal conviction. A lot of people have noted to me, one person in particular said that he believed that once an employer sees that tick box, they already rule you out. So there are many people who are excluding themselves from the running, and we'd like to give them the opportunity to compete. So before we get into some of the details of the legislation and a few terms and definitions that I'd like to give you to help you to understand some of the presentations on the webinar today, I wanted to test your knowledge. So you will see a screen pop up now, and I'd just like to ask you to answer that, and we will give the results in 1 second. Okay, so thank you very much for the quick responses. So what we found with the question, anybody with a criminal conviction must always tell an employer about it when asked. You had 40% of you stating that it was true and 60% of you stating that it was false. In fact, it was a little bit of a trick question. So for most roles, only unspent convictions need to be disclosed to the employer when asked. Now, unspent convictions are something that's defined by a legislation called the Rehabilitation of Offenders Act. It means that, for example, if someone receives a fine in court, they would have to disclose that conviction to an employer when asked for a year. On the other end of the spectrum, if someone has a prison sentence of over 4 years, that is never spent, so they would always have to disclose it when asked. The really important thing to note is that is only when asked. So if you want to know as an employer, it's your responsibility to find out. Now, for other roles, which are called regulated roles, these are exempt from the Rehabilitation of Offenders Act. And for those, you may well be able to ask for more information, including spent convictions. So those are the convictions that otherwise would have been passed and would no longer need to be disclosed to employers. You can see on your screen a table which sets out the kind of checks and different information that you can find out for those roles. For unregulated roles, the ones where only unspent convictions need to be shared, that information can be verified by a basic disclosure. That's not the same as a full check. That just shows you those unspent convictions that you may well have already asked someone about. For the regulated roles, you can conduct DBS checks. This is through the Disclosure and Barring Service, which was formerly known as CRB. Those checks depend on the different level and type of role, but will tell you other convictions, spent convictions, and in many cases cautions, although some will be filtered. Now, we're not going to go into a huge amount of detail on these today, but you will see at the bottom of your screen that there's a link in there which will give you some further information if you would like to find out more and you do recruit for regulated roles. What I would say, though, is that there is no legal requirement to ask up front about criminal records. As long as you are putting the risk management in place for those regulated roles, then you are free to choose as an employer when and how you ask about convictions. So, if you don't ask at the first stage, when would you ask and how would you do so? There is no single way to do this, and employers will want to take a decision about what works best for them. You could choose to ask at SIFT and have that information in time for the interviews, at the interview, post-offer of employment, or not choose to ask at all. The reasons for each of those options will depend on your company, but there are case studies on our website which set out some of those different options for you. The thing that I would note is that generally the later you leave that decision-making process and that request for information, the more likely you are to assess skills first. Many employers would request information in writing through something that's often called a dit-out. What was the context behind that conviction, how much time has passed since, and what have they put in place to move beyond that experience that they had. We would always suggest as well that you have a chance to talk it through with the applicant. Ask those questions, make sure that you've got the information that reassures you, and make sure that you are able to fully assess the risk that you want to for those roles. And importantly, you are able to request those checks that are listed on there, the basic disclosure through Disclosure Scotland, which does cover the whole of the UK, for unregulated roles, and those DBS checks for the regulated roles. But it's also important to remember that there isn't much information provided on there, so it'd be worth also asking people for verbal or in writing information about the contextual information that will really help you to make that decision. And once you've decided when and how you're going to ask in a way that works for your company, there are really a few things to remember and people to remember as well, because there are people applying for these roles and behind those convictions. Applicants are sharing sensitive information about themselves, so please bear this in mind and let them know how you'll handle that. Manage their expectations, make sure they know how their information will be dealt with. the recruiters and hiring managers also may not be fully aware of the criminal record legislation, what they need to know and how they should manage that information. They might also be really keen to take someone on but not sure how to do it. So if you give them that information and also give them the license to hire, show them that you're willing and keen to take people on who have convictions, then that can increase the chances of people getting through your recruitment process. The decision, as I know you'll be aware from the information that we've shared so far, shouldn't be dealt with in a subjective way. So if you're asking, you need to consider how you're going to assess that information fairly, to consider the real risk to the role, not the perception that you have around it. That can be done through risk assessment processes, also some of the tools that I know that Tony may talk through later today about how they've managed it within RICO. And finally, once the decision's made, and in that case where you have decided to hire someone with a criminal record, then you need to consider how that information is managed. We would really recommend that sharing of information is limited and only on a need-to-know basis. This is not just to protect the individual, but also to make sure that you have that control over what is shared within the company, just as you would with any other sensitive information about your employees. Now, before I move on to some further information about the diversity agenda that we're covering today, I'd just like to come to our second poll. So you'll see a question on your screen, and I'd like you to respond to this now. Okay, so we had a mixed bag of opinions out there. 56% of you thought this was true, that it is legal for employers to discriminate against job applicants with a criminal conviction, and 44% believe that it was false. Now, having a criminal record and the unspent convictions that people may well be sharing with you during the recruitment processes, that is not a protected characteristic. So it is legal for you to take this into account. You can choose whether or not to hire based on that information, and it's up to you to do that. The important word in this question, however, is discriminate, and what we would really like to see in all the guidance that's out there from both the Disclosure and Barring Service and other charities working in this area is that this information, as I was stating before, should be based on fact, not bias. So we would really hope that the decision-making process is about real risk, not discrimination. However, interestingly, in the US, where this campaign originated and where we stole the idea from, the campaign grew from equal opportunities legislation tackling indirect discrimination against BAME groups. States and cities across the US have implemented ban-the-box legislation both for private and public sector employees in different ways. There you will see an image on your screen. Actually, I double-checked the numbers and they've slightly upped since that image was provided to us. And now, since 1998, when the campaign launched, 16 states and 100 cities and counties have implemented some kind of ban-the-box legislation. Now, the reasons behind this and the reasons why this was made legislation through a link to indirect discrimination is because of the statistics. You may be surprised here or may not that there is a much higher chance of going to prison in the US if you are a black man. The statistics state that for a black man, there is a 1 in 4 chance of going to prison during their lifetime in the US, a 1 in 6 chance for Hispanic males, compared to a 1 in 23 chance for white men. Now, as I will come on to in a second, the reasons behind this are really, really complex. But what it does show is that if people are excluding applicants with criminal convictions in the US, then they may well be indirectly discriminating against BAME groups. And what you can see from some of the statistics that appear on your screen is that since the implementation of ban-the-box in various different states, it really has had an impact. For example, in Minneapolis, which banned the box back in 2007, there was a huge increase in the hiring of applicants with criminal convictions compared to 7 years prior to that. Now, how does this compare to the UK? There are many, many factors at play that cause some of the statistics that are on your screen now, from potential bias in the sentencing to a difference in socioeconomic backgrounds. And it really is not for all employers to be solving some of these background problems. However, what you'll see when it states, for example, that 26% of the prison population is from a minority ethnic group compared to 1 in 10 of the general population, is that there is a disproportionate representation of BAME groups in the justice system. So what we can conclude, as with the US, is that there is likely to be a disproportionate effect on BAME groups if people with criminal records are excluded from roles. Now, a recent survey from the Recruitment and Employment Confederation just a couple of months ago showed that almost 8 of 10 employers plan to hire more permanent staff in the next 3 months. As the post-2008 levels of unemployment continue to go down, we really see that there's a need out there to recruit and a need to do so in a new way. And Ban the Box can be part of how you recruit differently, accessing diversity in the broader sense of that word. I'd just like to finish by sharing some of the information about the campaign so far. As you'll see on your screen, 42 employers with a collective workforce of over 270,000 have already signed up to the campaign. They're from a wide range of different sectors and sizes. And as you'll see there are a huge number of different employers that you know and may not know as well, and it really is relevant to all businesses.